Chapter 7, Crimes Against Persons. The investigative sequence. Objective investigative work is one of the many ways officers earn the public trust. When you respond to a call for service, always preserve life first and then work to preserve the scene for investigation. So again, life first and then preserve the scene. Then we're going to go through the basic investigative flow chart. The first step is, after the scene is secure, tend to any medical needs of victims, witnesses, or suspects. Then you protect the integrity of the scene. Then you use sensitivity when engaging with the person on the scene. Determine if a crime actually occurred. Understand your responsibilities and agency limitations. Identify and separate victims and witnesses to reduce contamination. Do you have jurisdiction? If yes, continue. If no, refer to the proper agency. Make sure then to notify a supervisor, the type of crime, complexity of the case, if you need assistance, and will the detective respond. If the detective will respond, maintain the scene and start a log. Prioritize duties, interviews, evidence, documentation, arrest, or BOLO. And then top things to remember, determine, and document. Determine who the victim is, what relationship they have, determine domestic violence or not, special classifications, and a whole lot of things here. Reduce scene contamination by controlling who enters the area and establishing a crime scene. Course of action. 3 issues to identify at this stage are: who is the victim? Are there any impartial witnesses to the crime? And does the victim have a relationship with the suspect? Understanding the role of each person involved in an incident provides a foundation for identifying the victim of a crime. Remember, foundation for identifying the victim of the crime is to understand the role of each person involved. Then we have the instrumentalities of the crime, and these are the items used by the defendant to commit the crime. If a detective is able to respond, maintain the scene and start a crime scene log, like I said before. Provide the victim with the case number and the primary officer's name, and explain the follow-up procedures. Then we move on to victims' rights. Marsy's Law, M-A-R-S-Y-S, Marsy's Law requires that officers provide all victims and their families with the following information. Long list here. I'm going to try to breeze through them real quick. Due process, freedom from intimidation, harassment, and abuse, accurate and timely notice of all case public proceedings, including pleas, trials, and sentencings. Within the judicial process, reasonable protection from the accused. Prevent the disclosure of information on records that could be used to locate or harass the victim. Consult with the prosecuting attorney concerning any plea agreements. Be informed of all post-conviction process and procedures. Return of property no longer needed. Full and timely restitution. Proceedings free from unreasonable delay. And be informed of the rights and what they can do to seek help and reach out to an attorney. Because the Florida statutes mandate distributing this information, document and report that you gave them to a victim. This would be your victim case cards, victim brochures, things like that. The Victim Rights Brochure. This brochure gives the information, it gives the ability of crime, victim compensation, crisis intervention services, the role of the victim in the criminal or juvenile justice process, the stages of the criminal or juvenile justice process, the right of the victim to be informed, present, and heard during criminal or juvenile justice proceedings. If the victim is incarcerated, the right to submit written statements. Notice of Legal Rights and Remedies Brochure. This has to do with victims of domestic violence must also receive the Notice of Illegal Rights and Remedies, dating violence, repeat violence, and sexual violence, and the stalking brochure. So, Notice of Legal Rights and Remedies, it defines domestic violence, sexual violence, dating violence, repeat violence, and stalking, what Florida domestic violence law means and how it helps the victims, what to do if abuser violates an injunction, the victim's information that is exempt from public inspection, and who the victim should contact for more information. Then you have your sexual battery, your rights and services brochure. Then we'll move to the chart here, and I'll walk through the 4 different brochures and who to give them to. So all crime victims, a witness should receive 2 things. So everyone always receives 2 things: the Victim Rights Brochure and the Marsy's Law card or brochure. Then, if you're a victim and witness of domestic violence, you receive those 2, Victim Rights, Marsy's Law, and the Notice of Legal Rights and Remedies. If you're a victim and witness of sexual battery, you'll receive, again, the first 2, Victim Rights Brochures, Marsy's Law card, and the Sexual Battery, Your Rights and Services. And if you're a victim and witness of domestic violence that involves sexual battery, you receive all 4, Victim Rights, Marsy's Law, Notice of Legal Rights, and the Sexual Battery. So again, if it's just for sexual battery, you're getting the Sexual Battery one. If it's for domestic violence, you get the Notice of Legal Rights. And if it's sexual battery with domestic, you receive all 4. Legally required transport. You may also be legally required to transport victims and witnesses of certain crimes, such as domestic violence, sexual battery, or child abuse. When you finish transporting a person, conduct a vehicle check after they have exited the vehicle. Then we're moving on to assault and battery. An assault involves verbal or nonverbal threats. For assault, document that the suspect intentionally and unlawfully threatened by either word or act to do violence to a victim, at the time appeared to have the ability to carry out the threat, and created in the mind of the victim a well-founded fear that violence was about to take place. So again, 3 things for assault: intentionally and unlawfully threatened by word or act. At the time of that act or threat, they appeared to have the ability to carry it out, and they created in the mind of the victim a well-founded fear. The person who commits assault commits a misdemeanor of the 2nd degree. For aggravated assault, document that the suspect committed all the elements of assault and made the assault with a deadly weapon without intent to kill or with an intent to commit a felony. So again, assault are those 3 things, where aggravated assault is all those things except with a weapon. A weapon is a deadly weapon if someone uses or threatens to use it in a way likely to cause death or great bodily harm. A person who commits aggravated assault commits a felony of the 3rd degree. Battery. For battery, document that the suspect did 2 things, or one of 2 things, rather: actually and intentionally touched or struck the victim against their will, or intentionally caused bodily harm to the victim. If the victim is pregnant at the time of the battery, whether the suspect knew or should have known they were pregnant, this also upgrades a battery charge to aggravated battery. For aggravated battery, document that the suspect committed battery and intentionally or knowingly caused great bodily harm, permanent disability, permanent disfigurement to the victim, or use a deadly weapon. So again, aggravated battery, they intentionally touched or struck somebody, and they used a deadly weapon, or they cause great bodily harm, permanent disfigurement, or permanent disability. Then we have felony battery. So with felony battery, bodily harm is a result. The result of bodily harm is an accident, but the act of it happening in any way would make it a felony battery. So for felony battery, document that the suspect actually and intentionally touched or struck a victim against their will and caused significant injury, great bodily harm, permanent disability, or permanent disfigurement to the victim. When a suspect has 1 prior conviction for battery, aggravated battery, or felony battery, and commits any second or subsequent battery, the charge is reclassified from misdemeanor battery charge to a felony battery charge. Felony battery does not involve a conscious intent to cause great bodily harm. However, it does include the intent to touch or strike a victim against their will. So again, like I was saying, with felony battery, you intentionally hit them, but the extra result of them having this serious bodily injury was an accident, but it's still charged as a felony battery. Remember, if you have a prior conviction for battery, aggravated battery, or felony battery, and you commit a second one, any second type of battery, it gets reclassified from a misdemeanor to a felony. Then you have domestic battery for strangulation. This is a felony battery that is a battery against a family or household member or someone with whom the victim is in a dating relationship. Then we move on to reclassifications. This can occur when the victim is 65 years or older, or is an employee of a school, public or private, a sports official, an emergency medical care provider, a firefighter or police explorer, a public transit employee, a criminal justice officer, a traffic accident investigative officer, a security officer employed by the board of trustees at a community college. To reclassify the crime properly, establish that the victim was performing job duties at the time of the assault or battery, and the suspect knew or should have known that the victim was one of the workers listed in Chapter 784. So again, they had to be performing their job duties, and the suspect knew or should have known that the victim was one of those workers. Then we move on to assault or battery of a correctional facility employee requires 5 more elements to reclassify the crime. The suspect was in custody in a correctional facility. The suspect intentionally touched, struck, or attempted to touch or strike the victim against their will. The suspect intended to harass, annoy, threaten, or alarm the victim. The victim was a correctional facility employee, and the suspect knew the victim or had reason to know the victim was a facility employee. Then we have warrantless arrests. Chapter 901 of the Florida statutes allow you to make an arrest for assault without a warrant when the assault occurs in your presence, during a domestic violence situation, or upon a law enforcement officer, firefighter, an emergency medical care provider, a public transit employee, or another officer. So again, warrantless arrests either in your presence, during a domestic violence situation, or on another law enforcement officer. Then we have domestic violence. Chapter 741 of the Florida statutes define domestic violence as any assault, aggravated assault, battery, aggravated battery, sexual battery. I don't know why it has it listed twice here. Yeah, sexual assault, sexual battery, stalking, aggravated stalking, kidnapping, false imprisonment, or any criminal offense resulting in physical injury or death of one family or household member by another family or household member. That is domestic violence. A family or household member is defined as a spouse, former spouse, persons related by blood or marriage, persons who live together as a family or who have lived together in the past as a family, and people who are parents of a child in common. With the exception of people who have a child in common, the family or household members must currently live or in the past live together in the same dwelling unit. So if you have a child in common, you don't have to have lived together. That can be domestic. But when it comes to family members that are related by blood, they had to have lived together in the past or currently. So if you have an aunt that you never lived with and you met him one day and beat him up, that would not be domestic. In Florida, when you arrest a person during a domestic violence incident, the actual criminal charge will not be for domestic violence. Instead, the charge will be for assault, aggravated assault, battery, or aggravated battery. It's the relationship that determines it being domestic violence, but it is not listed as domestic violence. Domestic violence is not a crime. The most dangerous time of a domestic violence call is when you approach, as the abuser may know that you are coming. Arrest is the preferred response only for the primary aggressor, not for a person who acts in a reasonable manner to protect themselves or a family member from violence. Make sure to compare statements from the victim, witnesses, and the suspect. Dating violence is violence between people who have or have had a continuing and significant relationship of a romantic or intimate nature. This is based on a dating relationship within the past 6 months. The character or the relationship includes the expectation of affection or sexual involvement. The frequency and type of interaction must have occurred over time and on a continuous basis. The decision to investigate, arrest, and charge does not require the victim's consent. So you don't need someone to say they want to press charges. You just arrest anyway. Responding to a domestic violence incident, it may be necessary for you to return in 24 to 48 hours to document or collect more evidence or information, including photographs of physical injury and property damage. Then we have a no-contact order. This is given by the judge, and you arrest if the person is violated. A no-contact order prohibits any communication, oral or written, with the victim or person named in the order, physical or violent contact with the victim, or presence within 500 feet of the victim's residence, vehicle, or workplace, or a specific place that the victim or person named in the order visits regularly. Chapter 741 of the Florida statutes allows you to make an arrest for a violation of a no-contact order if the original arrest was for domestic violence. Then you have an injunction. This is made by the victim generally, and you also arrest if violated. Although an injunction is a civil action, its violation has criminal consequences. Law enforcement honors injunctions from other states or countries and can advise a victim to ask the local clerk of the court to reissue the injunction in Florida if the victim is now residing here. Chapter 901 of the Florida statutes allow you to make a warrantless arrest for violation of injunction for protection. Child-to-parent domestic violence. Child domestic battery occurs when a child commits an act of violence against a parent, sibling, or other family member living in the home. You can also make an arrest based on ongoing risk level of harm to others. Make sure to refer families to the Florida Network of Youth and Family Services for local and statewide resources for emergency shelter services and individual and family counseling. Documentation. Florida law requires you to document any allegation of domestic violence with a written report. Florida law also requires you to send a domestic violence report to your nearest local certified domestic violence center within 24 hours of receiving notification of the reporting of the incident. Stalking crimes. Stalking involves unwanted and repeated attention, contact, or harassment by the suspect towards the victim. Stalking occurs when the suspect willfully, maliciously, and repeatedly follows, harasses, or cyberstalks the victim. Maliciously means wrongfully, intentionally, without legal justification or excuse, and with the knowledge that injury or damage may or will be caused to another person or their property. Aggravated stalking. Aggravated stalking occurs when the suspect willfully, maliciously, and repeatedly follows, harasses, or cyberstalks the victim, and makes a credible threat to the victim. So the difference between stalking and aggravated stalking is making a credible threat to the victim. And the difference between assault and this aggravated stalking is with aggravated stalking, it just needs to be a credible threat, or with assault, it has to be them having the apparent ability to do so and the ability to do it immediately. A credible threat is a verbal or nonverbal threat, or a combination of the two, that places someone in reasonable fear for their safety or the safety of their family and friends. So it's not immediate fear, it's just reasonable fear. Cyberstalking. Cyberstalk means to engage in a course of conduct to communicate or cause the communication, directly or indirectly, words, images, or language, by or using electronic mail or electronic communication directed at or pertaining to a specific person, causing substantial emotional distress to that person and serving no legitimate purpose. A backup officer may transport the victim and any children to a domestic violence center. Lesson 4, child abuse. Corporal punishment by a parent or legal custodian for disciplinary purposes does not constitute abuse when it does not result in substantial harm to a child. If a reasonable parent or adult would not engage in a damaging act toward the child for any valid reason, especially when the primary purpose is to cause the child unjustifiable pain or injury, the act is deemed malicious and is child abuse. Chapter 827 of the Florida statutes outline the elements of child abuse. For child abuse, document that the suspect knowingly or willfully abused a child younger than 18 by intentionally inflicting personal, physical, or mental injury, committing or an intentional act that could reasonably be expected to result in physical or mental injury, or actively encourage another person to commit an act that results in or could reasonably have been expected to result in physical or mental injury to a child. So it's really two things: intentionally inflicting physical or mental injury, committing an intentional act that reasonably expect to hurt somebody, or having somebody else do that act. Chapter 39 of the Florida statutes defines physical injury as death, permanent or temporary disfigurement, or impairment of any body parts. Different types of harm can include a sprain, dislocation, or cartilage damage, bone or skull fracture, brain or spinal cord damage, or intracranial hemorrhage, injury to any internal organ, asphyxiation, suffocation, or drowning, or burns or scalding, cuts, laceration, punctures, or bites. A mental injury from child abuse is an injury to the intellectual or psychological health of a child. So physical is obviously physical, mental has to do with the mental, intellectual. For aggravated child abuse of a child younger than 18, document that the suspect committed aggravated battery upon a child, willfully tortured a child, maliciously punished a child, willfully and unlawfully caged a child, or knowingly or willfully committed child abuse causing great bodily harm, permanent disability, or permanent disfigurement. Child neglect. Neglect occurs when a caregiver fails to provide food, nutrition, clothing, shelter, medicine, and medical services essential for the well-being of a child, regardless of the age. Child neglect is more than a failure to use ordinary care. It is a gross and deliberate negligence committed with disregard for the safety of the child. In the context of child neglect, a caregiver means a parent, adult household member, or other person who is responsible for a child's welfare or who might have the legal custody of the child. Legal custody means a legal status created by a court, the right to have physical custody of a child, and the right and duty to protect, nurture, guide, and discipline a child, or the right to provide a child with food, shelter, education, and ordinary medical, dental, psychiatric, and psychological care. Then we have contributing to the delinquency of a dependency of a child. For contributing to the delinquency or dependency of a child younger than 18, document that the suspect committed an act that tended to cause, encouraged, or contributed to a child becoming a delinquent or dependent child or a child in need of services, or by act, threat, command, or persuasion, induced or endeavored to induce a child to commit or perform an act, follow a course of conduct, or live in a manner that causes or tends to cause the child to remain a delinquent or dependent child or a child in need of services. Goddamn, if I say child one more time. A man 21 or older who impregnates a child younger than 16 contributes to the delinquency of the child, even if the victim consented. So a 21-year-old with a 16-year-old, if he gets pregnant, that is contributing to the delinquency of a child. Then we have a CPI, a Child Protective Investigator. The Florida statutes authorize a CPI to remove children from a parent's or caregiver's custody and control without a custody order. If this occurs, make sure that the child's removal happens with as little trauma as possible. If you reasonably believe a child has been abandoned, abused, or neglected, contact your supervisor in the DCF Abuse Hotline. Use procedural justice, which can help reduce tensions and limit the trauma experienced by all parties. The Florida statutes require all individuals to report any suspicion or knowledge of child abuse, neglect, or abandonment by calling the Abuse Hotline. Do not place the CPI's personal identifying information, date of birth, home address, etc. in your report, as employees of DCF have the same confidentiality protections as law enforcement. Then we move on to abuse of an elderly person. Abuse of an elderly person or disabled adult occurs when the suspect knowingly or willfully subjects an elderly person or disabled adult to behavior that could reasonably be expected to result in the physical or psychological harm or death of the victim. Note that the suspect intentionally inflicts physical or psychological injury, commits an intentional act that could reasonably be expected to result in physical or psychological injury, actively encourages another person to commit an act such as the one listed above, intentionally and without lawful authority isolates or restricts access to family members for any length of time that can reasonably be expected to result in physical or psychological injury or to conceal criminal activity. Aggravated abuse of an elderly person or disabled adult occurs when the suspect commits aggravated battery upon an elderly person, willfully tortures, maliciously punishes or willfully and unlawfully cages the victim, or knowingly or willfully abuses the victim and causes great bodily harm, permanent disability, or permanent disfigurement. Neglect of an elderly person or disabled adult occurs when the suspect willfully fails to provide the care, supervision, and services necessary to maintain the physical or mental health of an elderly person or disabled adult, or fails to make a reasonable effort to protect the victim from abuse, neglect, or exploitation by another person. The suspect must be a caregiver for the victim. A caregiver here means a person who has been entrusted with or has assumed responsibility for the care of an elderly person or disabled adult and their property. A facility means any location that provides day or residential care for people who are elderly or disabled. The elderly person or disabled adult may have a fiduciary or someone who is legally responsible for managing their health and well-being or make decisions regarding their property and finances. Exploitation of an elderly person or disabled adult occurs when the suspect takes or attempts to take a victim's property, funds, or assets, or abuses a special relationship between them and the victim that results in an unauthorized seizure or other qualifying social, financial, or physical hardship or neglect suffered by the victim. So exploitation is taking their property, funds, or assets. The elements of exploitation may appear similar to fraud or theft, but should be charged as exploitation because of the victim's vulnerability and the suspect's relationship with them. Exploitation frequently occurs with abuse or neglect of an elderly person or disabled adult, which is something to be alert for when responding to these types of calls. Remember, signs of abuse, neglect, or exploitation may not be obvious. Then we move on to an API, which is an adult protective investigator. APIs can conduct an emergency forcible entry without a court order. Always document the incident even if you do not find evidence of a crime. The API, Adult Protective Investigator, will decide whether to remove the victim from the home and when and where to place the person in protective custody. The law authorizes an API to conduct an emergency removal without a court order with specified medical personnel or law enforcement. If this occurs, help the API lawfully conduct their duties, ensuring the safety of everyone involved. If the victim tells you that they consented to the alleged criminal activity, this should not end your investigation, as they may lack the capacity or be duly influenced into providing consent. Course of action, make sure to refer these types of people to the Florida Senior Legal Helpline, or if they're disabled, refer them to the Disability Rights Florida. Refer them to the Disability Rights Florida at this number. Disability Rights Florida. That sounds really weird. Disability Rights Florida. Okay. Chapter 415 of the Florida statutes authorizes you to provide transport or arrange for transport of an elderly person or disabled adult to the appropriate facility. Then move on to lesson 6 here. Interference with custody. To establish probable cause for interference with custody, document that the suspect knowingly or recklessly took or enticed or aided, abetted, hired, or otherwise procured someone else to take or entice a minor or incompetent person from the custody of the parent, guardian, public agency, or any other lawful custodian, or is the parent, whether nature or adoptive, step-parent, legal guardian, or relative, who has custody, and who took a minor or an incompetent person with malicious intent to deprive the other person of their right to custody. So all that is basically saying that someone knowingly did it or hired somebody to take either a younger person or an incompetent person from the other person without their right. And depriving that person of seeing that person. Basically what all that is saying. The parent or guardian must have knowledge of the court order regarding custody or receive notice of the pending proceeding to make the elements of interference with custody. The Florida order will not necessarily be the proper and enforceable one. Recall that you may not enforce a court order issued by another state or jurisdiction unless the court domesticates. So remember, in regards to child custody orders, if there's ones from different states, just because they have one from Florida does not mean Florida is the right one to enforce. You definitely don't want to get involved there. Do not attempt to determine which order is enforceable. Contact your supervisor to determine how to proceed. Luring or enticing a child. The difference between interference with custody and luring or enticing a child is that interference with custody does not involve the intention to commit other crimes, while luring or enticing requires the suspect to have the unlawful intention to commit other crimes, such as sexual battery. For luring or enticing a child, document that the suspect is 18 or older and intentionally lured or enticed or attempted to lure or entice a child younger than 12 into a structure, dwelling, or conveyance for other than a lawful purpose. For false imprisonment, document that the suspect forcibly by threat or secretly confined, abducted, imprisoned, or restrained the victim against their will without lawful authority. Confining a child younger than 13 against their will and without the consent of their parent or legal guardian is also false imprisonment. Kidnapping. Document that the suspect forcibly by threat or secretly confined, abducted, imprisoned, or restrained the victim against their will without lawful authority and acted with intent to do at least one of the following. Hold the victim for ransom or reward. Use them as a shield or hostage, commit or help with the commission of a felony, inflict bodily harm upon or terrorize the victim or another person, interfere with the performance of any government or political function. Kidnapping is both a state and federal violation. Kidnapping a child younger than 13 is a life felony when committed with any of the following crimes: aggravated child abuse, sexual battery, lewd or lascivious battery, molestation, conduct, or exhibition, child prostitution, exploitation of a child, and human trafficking. Make sure to notify your supervisor and command staff immediately. All right, hang in there, guys. Almost there. Well, not really. 8 more pages. Definitions in regards to missing or missing endangered persons. A missing child is a person younger than 18 whose temporary or permanent residence is in Florida, whose location is not known, and who is reported missing to a law enforcement agency. A missing adult is a person 18 or older whose temporary or permanent residence is in Florida, whose location is not known, and who is reported missing to a law enforcement agency. So basically the same exact thing for a child and adult. This is just younger than 18 and older than 18. An endangered person is any one of the following: a missing child younger than 18, a missing adult younger than 26, a missing adult older than 26 and believed to be in danger or the victim of criminal activity, a missing adult 18 or older who meets the criteria for a silver alert or a purple alert. Depending on agency policies, persons with diminished developmental or intellectual capacity, regardless of age. Then we move on to a missing child alert. A missing child alert must meet 4 criteria. The child must be younger than 18. The law enforcement agency's preliminary investigation must conclude that the child is in danger or serious bodily injury or death. Descriptive information or a photograph of the child must be available, so there has to be descriptive information or a photograph. The agency of jurisdiction must approve the issuance of the missing child alert. An Amber Alert must meet 5 conditions. 1, the child must be younger than 18. 2, there must be a clear indication of adoption. 3, the local law enforcement agency of jurisdiction must recommend the activation. 4, a detailed description of the child, the abductor, or the vehicle to broadcast to the public must be available. 5, the law enforcement agency's investigation must conclude that the child's life is in danger. Silver Alert. The statewide Silver Alert aids local law enforcement in the rescue or recovery of a missing adult who suffers from dementia, Alzheimer's disease, or other mental disabilities. The Florida Department of Transportation, FDOT, and the Florida Highway Patrol, they broadcast vehicle information about the missing persons to motorists and the public. And they use MEPIC. So that is the messaging system and other advisory methods. They don't give the definition of MEPIC here, but it's basically all those messaging boards. That is MEPIC, and that is done through the Florida Department of Transportation and the Florida Highway Patrol. To qualify for a Florida Silver Alert, the subject must be 60 or older, or a person age 18 to 59 who lacks the capacity to consent, and the person must have an irreversible deterioration of intellectual facilities that has been verified by law enforcement. The Florida Department of Elder Affairs is another resource for local law enforcement to aid in the rescue or recovery of cognitively impaired missing persons. We'll move on to a Purple Alert. The statewide Purple Alert aids local law enforcement in the rescue or recovery of a missing adult who has one or a combination of the following: a mental or cognitive disability that is not Alzheimer's disease or dementia-related disorder, an intellectual disability or developmental disability, another physical, mental, or emotional disability that is not related to substance abuse. The missing adult must not meet the criteria for activation of a Silver Alert, and people with a Purple Alert may be broadcasted through lottery terminals. Blue Alert. The Florida Blue Alert uses technologies employed by the Amber Alert to notify the public of critical information when a law enforcement officer has suffered serious bodily injury, is killed, or is missing while in the line of duty, and the suspect poses a serious threat to the public. Under the Blue Alert Plan, FDLE, Department of Highway Safety Motor Vehicles, Florida Highway Patrol, and the Florida Department of Transportation immediately broadcast important information about the suspect when this information would help prevent further harm or help apprehend the suspect. And again, that is the Blue Alert Plan. Responding to a missing person incident. As soon as you determine that the person is missing, contact your supervisor. The initial search should include buildings and areas where someone last saw the missing person. Make sure to look for diaries, computers, cell phones, game systems, and other electronic devices which may contain evidence and useful information. If the missing person is not in the building, conduct a neighborhood canvass. Children with autism often seek bodies of water in nature, so check there first. Additional resources. The National Center for Missing and Exploited Children, NCMEC, works with law enforcement, families, and professionals on issues related to missing and sexually exploited children. NCMEC has a missing children hotline that serves as a national clearinghouse for information related to these issues. A Child is Missing, Inc. offers free assistance to law enforcement to help recover missing persons, individual children, teens, and the elderly. After providing this organization with the missing person's information, a recorded message will be developed and sent to homes and businesses within the requested radius. A Child Abduction Response Team, which stands for CART, again, that's a Child Abduction Response Team, is a multi-agency team that assists law enforcement to provide an organized and planned response to an abducted, missing, and endangered child. Next, we're moving on here to sexual offenses, lesson 8. Sexual battery is one of the most underreported crimes because the victim may be embarrassed or may actually have a continuing relationship with the suspect. Sexual battery is a non-consensual oral, anal, or vaginal penetration by or union with the sexual organ of another, or the anal or vaginal penetration of another, or any other object. However, it does not include an act done for a medical purpose. Consent does not include coerced submission and does not mean the victim failed to offer physical resistance. There are 4 types of people here that fall into this category. You have mentally defective. This means a mental disease or disorder that renders a person temporarily or permanently incapable of judging their contact. So, mentally defective means a mental disease or mental disorder. Mentally incapacitated, which means a person temporarily incapable of judging or controlling their own conduct due to the influence of narcotic, anesthetic, or intoxicating substances administered without their consent. So, mentally defective means they have disorders. Mentally incapacitated means they're on drugs, alcohol, intoxicated, and they can't consent in their right mind. Then you have physically helpless. That just means unconscious or asleep. And physically incapacitated, which means bodily impaired or handicapped. So, physically incapacitated, they're handicapped. Mentally incapacitated, they're drunk, on drugs. Physically helpless, they're unconscious or asleep. And mentally defective, they have a disorder. Initial response to sexual battery. The Sexual Battery Victims Access to Services Act provides victims of sexual battery access to medical intervention, advocacy, crisis intervention, and recovery services. Chapter 794 of the Florida statutes require you to provide or arrange for transportation of victims of sexual battery to an appropriate medical facility or rape crisis center. The victims' bodies and clothes contain valuable evidence. Only medical personnel can perform medical intervention in the form of an exam using a sexual offense evidence kit or rape kit. Reporting requirements. Documenting sexual battery includes a forensic report, a medical report, and a criminal report. So again, there's 3 reports for reporting sexual battery: forensic, medical, and criminal. Agencies must submit a sexual offense evidence kit or other DNA evidence for forensic testing to the statewide criminal analysis laboratory system within 30 days of receiving it. Then we move on to lewd and lascivious. Lewd and lascivious conduct is any sexual act considered to be highly offensive and contrary to common standards of behavior. Sexual activity means the oral, anal, or vaginal penetration. You guys know what that is. Consent means actively agreeing to do something or giving permission for something to happen. Consent does not mean the failure by the alleged victim to offer physical resistance to the offender. Coercion means the use of exploitation, bribes, threats, or intimidation to gain cooperation or compliance. Now we're talking about sexual offenses with minors. Sex offenses involving a person 25 or older who engages in sexual activity with a minor of 16 or 17. Make sure you notify your supervisor regarding this type of crime. So 25 or older cannot be with 16 or 17-year-olds. Sexual offenses involving children. The Department of Justice classifies child pornography as a form of child exploitation that can be prosecuted on the federal level. So again, child pornography is a federal crime. The Florida statutes define child pornography as any image depicting a minor engaging in sexual conduct. It may include children posing in a lewd and lascivious manner or performing a sexual act. It is illegal to produce, possess, or distribute child pornography. If you respond to a call involving child pornography on a computer or an electric device, under no circumstance should you touch the device or attempt to find more images on it. Sexual offenses committed by juveniles. Juvenile sexual abuse is any sexual behavior a minor engages in that occurs without the consent of the other person, without the other person's being in a position of equality with the minor or because of coercion. Sexting occurs as a crime when a minor uses a computer or other electronic device, such as a cell phone, to transmit or distribute a nude photograph or video to another minor. Sexting is a crime even if both minors consent to the act. So again, sexting is from a minor to another minor, and is a crime even if both minors consenting to it. Human trafficking. Human trafficking is a form of modern-day slavery. Chapter 787 of the Florida statutes define human trafficking as transporting, soliciting, recruiting, harboring, providing, enticing, maintaining, purchasing, patronizing, procuring, or obtaining another person for the purpose of exploitation of that person. 2 threshold questions will help determine if a person is a victim of human trafficking. 1. Did the suspect recruit, transport, or hold the victim in the service of another for labor or commercial sex acts? 2. Did the suspect get or keep the victim's service through force, threats, psychological manipulation, or confiscation of legal documents? Victims of human trafficking are subjected to force, fraud, or coercion for the purpose of sexual exploitation or forced labor. Neither federal nor state human trafficking laws require an element of force, fraud, or coercion to determine sex trafficking of children younger than 18 or an adult believed by the person to be a child younger than 18. So again, if they're younger than 18, you don't have to show force and fraud and coercion. You just automatically charge human trafficking and you take that person. Then we move on to responding to a death. All law enforcement officers will respond to the scene of a death at some point in their careers. When you are the primary responding officer, always consider 1. Safety first, 2. Providing first aid as necessary, and 3. Preserving the scene for further investigation. Manner and cause of a death. The cause of death is a specific injury or disease that leads to the death. So again, cause of death is the specific injury or the disease. The manner of death is the determination of how the injury or disease leads to death. The 5 manners of death are natural, accident, suicide, homicide, and undetermined. So again, the manner is one of the 5 manners, whether it be an accident, natural, whatever. And then the cause of death is that injury or disease. So gunshot wound, Alzheimer's, ALS, whatever. Homicide is the act of one human taking the life of another. There are subsections that identify types of homicide, including murder, justifiable homicide, vehicular homicide, manslaughter, and DUI manslaughter. After death, a body goes through a process of changes that include rigor mortis, stiffening of the body muscles, lividity, the color change from settling of blood due to gravity, often black and blue, and algor mortis, which is the post-mortem cooling of the body. Algor mortis is cooling, rigor mortis is stiffening. Evidence of changes is most valuable if assessed as soon after death as possible. The Florida statutes require law enforcement to notify the medical examiner as soon as reasonably possible, and do not disturb the body until authorized by the medical examiner. The officer and the medical examiner cannot determine the cause and manner of death independently. The medical examiner, in conjunction with the law enforcement investigation, make the final determination on the cause and manner of death only after completing their investigation, which can take weeks. The final identification must be 100% positive before contacting next of kin or releasing the information to the family. Identifying a deceased person can be as simple as obtaining the driver's license information, David, fingerprint scanner, and comparing the photo to the body. Initial response to death. Always approach the area of a crime scene and consider it a homicide until the information you gather consistently indicates otherwise. Interview. Interview the person who last saw the dead person alive and the person who found the body. Initial investigation. Determine if you have jurisdiction. If you do not, refer the incident to the proper agency and hold the scene until additional assistance arrives. If a detective will respond, maintain the scene and start a log. Response to an infant death. The Center for Disease Control and Prevention defines an infant as a baby younger than a year old. Sudden unexpected infant death, which is SUID, is a diagnosis given only after an investigation rules out all other possible causes of death. Again, that's a sudden unexpected infant death. Different types of sudden unexpected infant deaths are SIDS, sudden infant death syndrome, accidental suffocation and strangulation in bed, and other deaths from unknown causes. A thorough written documentation of the incident that includes your response is the final step in the preliminary investigation of the death. So again, a thorough written documentation is the final step in the preliminary investigation. Now we're moving on to robbery. Chapter 812 of the Florida Statutes outlines the elements of robbery. Robbery occurs when the suspect takes money or property from the victim, intends to permanently or temporarily deprive the victim of their property and takes it for their own or someone else's use, and uses force, violence, assault, or places the victim in fear during the incident. So again, it's taking the property, it's depriving them of the property, and then it's using some sort of force, violence, assault, or putting them in fear. Then we have robbery by sudden snatching. They took money or property of some value from the victim's person, intended to permanently deprive or temporarily deprive the victim of their property, and in the course of the taking, the victim was or became aware of the taking. So again, robbery by sudden snatching, two big things here, besides obviously taking the stuff, is that it has to be on the victim's person, and the victim has to become aware of the taking during the process. In this crime, the property must be on the victim's person, not just next to them, like I said. And again, that is the robbery by sudden snatching. Home invasion robbery. Home invasion robbery is often confused with burglary. Home invasion robbery occurs when a suspect enters a victim's home while the victim is present and aware that the crime is occurring. For home invasion robbery, document that the suspect entered the dwelling of the victim and intended to commit robbery. While inside the dwelling, they committed robbery and used force, violence, assault, or placed the victim in fear during the robbery. So again, in home invasion robbery is just simply a robbery in the home, and by being a robbery, they're putting that person in fear. Carjacking. The elements of carjacking are similar to robbery, except that the suspect took a motor vehicle. For carjacking, document that the suspect took the motor vehicle, intended to permanently or temporarily deprive the victim of their vehicle, and they use force, violence, assault, or place the victim in fear during the incident. If the suspect is armed during the carjacking, this enhances the penalty. Initial response to robbery. After the scene is secure, tend to any medical needs of victims, witnesses, or suspects, protect the integrity of the scene, and contact dispatch to initiate a BOLO if the suspect fled. A canvass is an inquiry of all possible sources of information surrounding the incident of a crime scene and happens most often when the suspect leaves the scene. The best time to conduct a canvass is immediately after or as soon as possible after the crime occurred. Be sure to document contact information and responses to questions from anyone you interview during the canvass. Include specific details about what they have heard or witnessed, no matter what information they provide. Even if they report knowing nothing, be sure to document any residences that are vacant or where there is no response. And that concludes Chapter 7.